All right. Thank you very much, everybody, for joining this first 2021 webinar organized by the SCTA NextGen. We know we're all busy, but I think it's an interesting subject. So today is our first webinar. We hope that next week we'll be able to share with you the agenda we prepared for you for the first half of the year, or at least until the October event, October 14th, which is the SCTA yearly event. We always try to find innovative and actual subjects that are affecting our daily working lives. So we hope it's going to be of interest to you. We're going to share it next week. And of course, don't forget that you can always reach out and propose new subjects or new speakers in order to continue with this interesting initiative. Today, we welcome Mr. Paul Rooke, the Executive Director of the BCA, the British Coffee Association, and Mr. Angus Kerr, Chairman of the Arbitration Committee at the BCA. And we're going to approach the arbitration. It's going to be only a 45-minute introduction. So in order to become really proficiency with this subject, as you would have studied maybe in school or in university, law deserves a bit more than 45 minutes. So it should just give you a high-level introduction to the subject and give you the willingness to learn more and maybe assist to what the BCA can offer in terms of teaching and courses in that regard. So, of course, this year will be mostly webinars. We don't expect to be able to provide you with any in-person conferences or after work, etc. So we hope that's going to be the case end of next year, end of this year again. But in order to start directly in, I will welcome Mr. Paul Rooke, who's going to introduce a bit the BCA, and then we're going to dive in directly in the subject of the arbitration. In order to ask questions, I would propose you direct them only to me in order to not distract the speakers. And of course, try to make it as clear as possible because it's a subject which is not that easy. So if you make it confusing, it's going to be hard for me to ask the speakers. So thank you very much. Thank you, Paul and Angus, for giving us the opportunity to learn from you. So please, Paul.
Thank you very much, and can I add my welcome to you all, and good morning. Good to see so many people on the webinar, and good really for us to be able to put this on. For those of you that are not aware, BCA represents all parts of the UK coffee chain, from trade right the way through to retail, and the provision of an arbitration chamber has long been a part of what BCA offers. And as an association, we're also keen to broaden our engagement with others. And so, you know, quite delighted that the SCTA NextGen approached us to put on this webinar today. So we're engaging much more widely now in policy and in other areas. Partly as the reason the UK has left the EU sector as a whole. A number of you may have previously attended the more in-depth 3-day BCA educational seminar, which we run on a biennial basis, so every other year. We were hoping actually to put it on in about a month's time, but obviously COVID has impacted on that, and we're still looking at how we run that maybe later this year or maybe into 2022. But within that seminar, contracts and arbitration are one of the areas that we study in more detail. And I guess partly as a result of where we've all been in the last year, but also I guess looking sort of further forward, we are exploring how we put more educational and training material online over the next sort of 12 months. So please look out for that. And obviously contracts and arbitration will be a part of that sort of package as we move forward. And for those of you that may be more interested in going further, we sort of also run regular events which are available to members of the panel of arbitrators if that's something that you want to get involved in. So certainly if you hear anything today that think can help you with, then please don't hesitate to get in contact with us. I mean, I've been involved in producing commodity contracts and running an arbitration chamber for a number of years in areas outside coffee, in other areas of the commodity sector. So I'm well aware that arbitration is an important tool for trading across all of commodities. But for it to be an effective tool, it's important to understand it. And like all legal processes, it's important to also understand what you need to do and when you need to do it in order to use the tool effectively and see the right results coming out. So what we're aiming today is, or certainly Angus is aiming today, is to give you really an overview of the main points around the BCA arbitration service. Something that is open to all and accessible to all parties, if that's the route you've chosen to go down when you enter into contracts. But as I say, for those of you who are interested in looking at the topic in greater depth, we will, as I said earlier, have some details of when our next educational seminar is going to take place as we start to move out of the COVID restrictions, and we'll be sure to sort of share that and advertise that through SCTA Next Gen as well. So that's really all I want to say today. More than happy to hear from people if you have queries after the event. You know, quite happy to have them passed back through me and through Angus. But probably now the best thing to do is to hand over to Angus, who, as the title indicates, is the chair of our arbitration and contracts committee, and he will lead you through the presentations and lead the question and answer session afterwards. So thank you, Angus. Over to you.
Thank you very much, Guillaume and Paul. I'm not very good at this sort of thing, so please bear with me, and welcome to all of you. It's nice to see so many people coming on these webinars and supporting it and hopefully learning something from it. We start at the beginning, contract. And you can see here, contract is defined as an agreement. But most contracts are entered into verbally. We normally just agree the type, price, weight, and shipment. We're very fortunate that we have a contract, form contract, the European coffee contract. And so we just incorporate those terms and conditions. It's important to know what those terms and conditions are. And we'll come on to that a little bit later. If we can have slide 2 now. What is arbitration? The object of arbitration is to obtain the fair resolution of disputes, and parties are free to agree how their disputes are resolved. And you know, they can change things and agree between them how they want things to run. For example, they can ask for one sole arbitrator if the two parties agree. There is a set procedure because normally when you go to arbitration, you're not talking to each other anymore, and so the BCA have a set of rules which allow you just to register with them and go ahead. The good thing about arbitration is that your problem is looked at by people from the trade. So they understand it. They understand what the complexities are and can get to the root of the problem and hopefully resolve it. Let's have the next slide, please. Now, the incorporation of the arbitration into the contract is important. It's important because if you've fallen out with a party and there's a lot of money at stake, they probably will run away and not, even when you get the award, run away and not want to pay you the money that you're owed. And to incorporate an arbitration into the contract in writing, you have the New York Convention you can go for, and you can get, you can claim globally. Next slide, please. Now, the role of the tribunal, it's not dissimilar to mediation. After all, we're all in the trade together, and so you have a problem and you put it to a tribunal, and the tribunal will look at the problem and they will go over it. It's often been said that we should have a mediation service, but to be honest, mediation has already taken place. Traders and the logistic team in the companies are the best mediators going. They've already mediated. They've banged their heads together. They can't get to it. Arbitration is not complicated. It's pretty simple. And I think the best way to try and explain how one should go about it is perhaps to try and get into the mind of the arbitrator. Here, of course, I speak for myself. Claimants' submissions arrive. On reading through them, it more often seems like an open and shut case. You look at it and you just, it's simple. It's an open and shut. So what I do is I make a finding of fact. And in making a finding of fact, when you receive the first set of submissions which come in from the claimant, you put everything in date and time order so that you then have a story. And then after that, you will receive the submissions coming in from the respondent. When you put that in and look through that and start putting in between your finding of fact that you had from the claimant, you suddenly find there's an email or an exchange in between that wasn't there originally. That one exchange can change the whole story. So the finding of fact is important. And this is something when you actually make your submissions, is do a finding of fact, go through every single bit of transaction, every single communication you've had, put in date and time order and read through it carefully. The next section, of course, is the contentions. Contentions is what you are saying about the case. It's saying that, he didn't follow such and such a rule, or he didn't ship on time, or whatever it is. Very often, parties don't put their contentions down clearly. Arbitrators have the task of trying to read through the submissions and work out what the contentions are. It's important to put down your contentions. Make sure they're in and properly done. And then it makes life simpler for the arbitrator. And your case is a much easier one to look through. Obviously, time is money, and the less time taken by arbitrators, the less it's going to cost you to get the award. I can have the next slide, please. Time limits are crucial and often overlooked. The contract has quite a few articles where time is very, very important. And if you do not follow those times, then you could lose a case. Putting somebody in default and not following the requisite times under the contract allows the person to escape. Under the arbitration rules, times can be extended under the arbitration rules. They're not obligatory. So arbitrators will bend over backwards to give more time for submissions to come in, but they will draw a line if people are taking far too long, etc., to come up with something. And have the next slide, please. Claiming arbitration, the process. You submit a non-returnable fee for the amount published by the BCA. But before you've done that, you've advised the other party that you are claiming arbitration, you're going to arbitration. And then when you put in your written submission for the arbitration, you will give the name of the other party, details and reference numbers to contracts in dispute, and evidence that you have advised the other party. The other party has to be kept informed. If we can have the next slide, please. The process, an application for arbitration is usually prepared by the claimant themselves, but you can get help. You can ask for lawyers, or you can go through the arbitrators and choose an arbitrator who's had experience in arbitrations, and he will probably lay it out in the way that I've explained earlier. But it's supposed to be cost-effective arbitration, and it's a simple mechanism. So remember, it costs money if you start employing people. Let's have the next slide, please. The arbitrators, they produce a reasoned award, setting out their views of the event. Now, I've seen some awards from other sectors, and they're so complex. And when you get, they're sort of legally written, and when they're legally written, it gets confusing. Arbitrators are just simple trade people. They're from the trade. They're from our own family, and so setting out their views and things, they try and make it as clear as possible as to how they've arrived at what they've arrived at from the submissions that have been put forward. Let's have the next. The first tier award is done. You get it. You don't like it. You can appeal. The appeal, you have to remember, is a completely new case. They don't see the appeal tribunal do not see anything except for the first tier award. They don't see any of the original submissions, so they don't know what was put in. All they see is the award. But remember, I said the awards, we try as arbitrators to make the awards as clear as possible, following the findings of fact and the contentions of the parties. So the tribunal will have a good sort of take on what was submitted from that. So when you do your appeal, be sure that you bring in new points and you bring it to the attention of the tribunal that what you want to put over and make it clear. Courts can be brought in, but it's very, very rare to have any court being brought in, and it's usually only brought in because there's been an error on the part of the arbitrators in procedure. Procedure is important. Arbitrators have to follow certain procedure, otherwise they can get themselves into trouble. The next slide. As with most things, details matter. And as I said earlier, the incorporation of your finding of fact and the contentions are very, very important to make clear and have clearly there. Keep the submissions clear, concise, and truthful. Don't be afraid to ask for help. Getting things right can be extremely rewarding. Now, we're always looking for younger, new people coming on board as arbitrators. We don't have many arbitrations, which is probably a question somebody will ask. We don't have many, but it's interesting to see other people's problems and keep yourselves out of getting into problems. It's incredible over the years what one learns from acting as an arbitrator, and from actually looking at the rules and having to follow the rules of the contract that we so readily use without really looking at it. So learning about arbitration, coming to courses on arbitration is always very, very interesting. You learn a lot, even if you never do an arbitration. You do learn, and you do learn more about the contract and what the contract conditions are. I'd like to ask if there's any questions or anything you would like me to go back on at this stage. I'm sure there are a few questions. I do like to have questions. And so if I can ask if anybody has any clarity they want.
Yeah, thanks, Angus. So far, we have a few questions. I don't know if you want to go through the next few examples you already set, or do you want to answer some questions at this stage?
I think if we have any questions at this stage, and then I think possibly go over some of the articles of the.
Excellent. Yes, excellent. So one question would be, as a practical case, you bought coffee from a supplier, he fixes in your book, the market goes up, and he delays the shipment, or basically is not performing as per the contract. You know is not going to perform. The market continues to go higher. What should you do as the buyer in order to protect yourself, protect your interest, and make sure you try to recuperate? So that's an example I want to ask you. What is your duty as the buyer when you face this kind of problem? The communication is lost, you don't get the feedback from your supplier, there's a problem. What should you do?
It depends on the timing of this. I mean, if you've got a shipment contract and the shipping period has gone by, then you have the article under the contract which you can follow, which we can go into later. There's little you could do unless he's actually come forward and said that he is not going to perform. If there's any communication you have, or if you're able to get a communication out of him whereby he has said that market's gone up, I'm not going to ship, then you can put him in a repudiatory breach of contract and bring the contract to a close and claim damages and close out the contract. That's a repudiatory breach of contract. So he has actually voiced the fact that he's not going to perform. We'll go on to the articles after if the shipping advice doesn't arrive on time, etc. But this is pre that happening. Repudiatory breach of contract you can also bring about if there's an intention, that he is not going to perform, or the party is not going to perform. So you can bring that in at any time, as soon as you get any notification or any advice that they're not going to perform the contract. That is what you need to do, a repudiatory breach of contract. Is that?
Yep. Yeah. What I wanted to mention to the audience was, you need, as the buyer, to minimize the costs. Meaning, in such cases, if you know that your shipper is not going to perform, you should buy back your hedges, right?
Yes.
Or if you know you're not going to get your coffee and you want to replace from the spot because you need to deliver to your customer, you need to act, right? Even if you don't have a clear situation, you have the responsibility to act in order to minimize the cost of this whole situation. Is that correct?
That is correct. I mean, so sort of in an arbitration, if a party has not acted diligently and in time, and to try and reduce costs after they've known a fact that it's not going to be performed, or the container's lying on the dock in 50-degree heat, etc., and they don't move that container because they've got a squabble going on, then any damages caused by that lack of diligence of that part can fall on them for not having acted. So yes, what you're saying, Guillaume, is absolutely correct. You have to act quickly to reduce any costs and minimize any losses.
Yeah, and if you didn't, and in the end you have a $100,000 loss, you might not get the award for that full amount because you didn't act yourself in order to minimize.
Correct.
Thank you, Angus.
Correct.
Another question we have is kind of easy. Once you get an award versus a company which is probably not in Europe, it might be difficult to enforce it. It might be difficult to effectively get what the award says. It would mean, I don't know, a certain amount of money. How can you enforce it? If it's a country, I mean, any country, but if it's outside Europe, it's even more difficult, I guess.
Yeah. Enforcement of awards is an interesting subject. Under English law and under the Arbitration Act, it is a fairly simple process to take. If you get any investment from the party that they're not going to honor the award, you can take it to a judge, and a judge will rubber stamp it in the courts in the UK and turn it into an order. And that order can then be turned into a global freezing order. Now, what a global freezing order means, and it's not a difficult process. What a global freezing order means is that you can then advise everybody that may be trading with that party or trading that there's a freezing order on them. That means that if they ship coffee and the bill of lading is out there, you can grab that bill of lading. You don't have to go to the country itself. You can grab any of their assets outside the country. So it's important when you have a dispute, particularly a large dispute, to know what the assets are and where the assets are. So have a search of the assets and then you turn your award into this freezing order, and you can grab those assets. If they've got a house sitting around somewhere because they've wealthy company or wealthy people, you can grab it. And so there are remedies to awards which are not being taken up.
Okay. So do you mean that if I buy from a supplier, he doesn't perform, but he continues shipping to other companies, even if these companies, they paid for the good, they paid for the coffee, you could seize them?
No, if they paid for them, they belong to them. But but before they pay for them, you can grab them. And what happens with a freezing order? I mean, so I've seen one in action not long ago, and it happened to be an Indonesian exporter who had been in trouble a number of times. He's no longer around, but they're fairly large, and this freezing order was out, and the party couldn't find any of the assets outside of Indonesia. So to try and claim in Indonesia was very difficult for them. So they got this freezing order. They then advised everybody they could think of in the coffee world that there was this freezing order. So as a result, the large manufacturers said to the traders, look, we're not going to take any goods from so-and-so. We're not going to take any goods from so-and-so and so-and-so because the name's out there. And as a result, the exporter couldn't do any business. Nobody would take any of his goods. So he came to the table, discussed and negotiated and settled.
Okay, but that's informal blacklist, right? There's no existence of a formal blacklist or something like this, right?
Yeah, it's a legal. Basically, it's almost like a legal blacklist to some extent. It just blocks any business they can do.
And do the awards? I mean, is there a place where we can see all the awards? Is that public or private?
No, awards are private. It is something which has been brought up several times by the legal profession, because any court cases is actually public and it's out there in the public domain. And of course, it makes precedents and it allows people to look at it and understand that this ruling can be made and that ruling can be made. Arbitration is not like that. Arbitration is private. It doesn't go into the public domain at all.
Okay, thank you, Angus. Now I think we should approach the timing limits for the people on the line and inform them that depending if you have a quality claim or a weight claim or a problem, whatever it is, you need to respect strictly the timeline. That's correct.
Yep.
So what is it the case in terms of a quality claim? The coffee arrives, you take delivery, you take a sample, you cup it, it's not good or it's not as good as it should be. How long do you have and what's the procedure in order to formalize the claim because you want to protect yourself?
On the, I think was that on one of our slides? I'm not sure. I can't remember if it was one of our slides. But
which article is it?
I think it's article. Was it article? No, hang on.
So now just for the audience, we've put down 4 articles here to look at. There's a lot of text, obviously.
Article 24.
All right.
Last one on this. Yeah, that's it. Article 24. You know, this is something which is interesting because claims must be clearly formulated within the following time limits. Quality claims not later than 28 calendar days from the final date of discharge at the port of destination. Now, that means it doesn't necessarily mean the final date of discharge. That can be extended a little bit. It's actually when you can get your hands on the goods. For example, if a container arrives and it's stuck in the port, the final date of arrival has been started counting, but the container's locked up. You can't get to your goods. So it's only when you can get to your goods is the final date of discharge. That's when the counting would start.
At the final port of destination, right?
The final port of destination, yes. So the formulation of the claim is important because here you need to have told the party that if it's a quality claim, I'm looking for $5 per 50 kilos because, you know, it was XYZ. So the quantum of the claim needs to have been established, because without the quantum, the party can say, well, we didn't know what you were claiming. So, we're not, they've got to know. So the formulation is important within that time limit.
Yeah,
and
that's clear.
Other claims, of course, not later than 45 calendar days from the final date of discharge. So again, those time limits are not extendable. They are part of the contract rules.
Yeah, and even if you're right and you are 2 days late, you might just be overruled.
You may be overruled, yes.
Yeah. Another question, please, Angus, is if you sell under the ECC rules and the buyer has put the GCA rules as the USA, what happens in case you didn't spot it out, right? You didn't notice, and then something happens, there's an arbitration, there's a dispute. How can you solve that? Is there a way? What counts?
What if they've got GCA arbitration on it, or what? Or GCA?
Well, the buyer has GCA in his purchase, and the seller has ECC rules in his sale.
Right.
Or the arbitration is London in one contract and New York in the other one, or is there's a mismatch in terms of arbitration place or rules? Can it be solved afterwards, or is that, I mean, what?
It can't. Well, the arbitration under the Arbitration Act, which is the 1996 Arbitration Act, the parties can decide themselves how they want their arbitration to be had. They can, I mean, for example, they could nominate only one arbitrator. They can make their own timetable for it. It's up to the parties to decide under the Act. When you have a confusing situation of two different contracts flying around, very difficult to establish which one is the right contract. And if it came to me, I would be asking both parties, which contract would you like to be to be heard under?
If they don't agree?
if they don't agree, it's,
Okay, yeah, that's a difficult. And if there's an agent in between, I understand from my own experience that it's the agent's contract that counts. Is that true?
oh, sure. The broker or agent's contract is the one that will be held up. So if there's a broker there, that's usually a fairly simple thing because there will be one contract on it. But you know, if there's an arbitration agreement in there, and the arbitration agreement happens to call for BCA arbitration, for example, under English law, the arbitrators would then have to look at the two contracts together. And I don't see any reason why an arbitration, if there is an arbitration agreement in there, couldn't take place using the two contract terms. It would be confusing. It would be a difficult one to do, but I don't see a problem. I mean, if I had two different set of rules, contract rules to look at, to decide on in an arbitration, I think I could come up with an award. I feel, you know, because there is an arbitration agreement, and a point that I should have made earlier is by incorporating an arbitration agreement in your contract, if somebody runs away from the first contract, you have a second chance. There's a second contract. The arbitration agreement is a totally new contract. So somebody runs away from the first one, that's your secondary contract. So it gives you a second chance, second bite at the cherry.
Okay, thank you. Do you know yourself if the ECC rules and the GCA rules are very different, or is there major differences, or?
They're not majorly different. I'm not that conversant with the GCA rules, not as conversant with these ones, which I've been involved with changing and playing around with. So, but then no, that I mean, they're not too different. Some of the time limits are different, but they're not overly different.
Okay, thank you. Do you want to go? I have other articles. We've got this.
Shall we look at one of this one? Yeah, this one, article 2. This is for claiming your arbitration. You know, and the formal decision to initiate arbitration proceedings shall be notified by one party to the other within the following time is quality, not later than 28 calendar days from the date the claim was formulated. So effectively, you've formulated your claim, you've said within, and you've drawn your samples. So you only have your 21 days to draw a sample on a quality arbitration. So remember that. You then have 28 days with which to formulate your claim from final date of discharge. And then quality claims not later than calendar day from the date the claim was formulated. So you have a further 48 days where you can be negotiating to try and sort out the problem. And then you say, well, we can't sort this one out, going to arbitration. So, and then any other disputes not later than 90 calendar days from the date one party formally notifies the other part of the dispute apparently cannot be resolved amicably. So your other disputes can go on an awful long time because you can talk about them, you can try and negotiate them, you can try and do other business, etc., but you can still keep it open. Once you have told a party that you're going to arbitration, then you have to act within the time. But it's only after you've told them you're going to go to arbitration.
Yeah, it's clear that you need to write to them, if you don't act until this date, I will start the arbitration procedure, and then you need to respect the exact calendar days. Otherwise, you're going to be out yourself on your own claim.
Yeah, you put yourself out of time that way.
Yeah. In terms of contract, if everybody in Europe put the ECC rules, is there anything that you would suggest to add as a buyer or seller in the contract on top of the ECC rules? Anything specific that you think is maybe missing, or some details should be clarified sometimes?
you know, for me, these rules are pretty, they're pretty much in depth. I mean, they've just rewritten the rules, and thanks to a couple of guys in particular, Kevin Furley and Mick Flynn, who spent an awful lot of time in composing and putting these rules together from the old rules that we had. And they're fairly comprehensive. At this stage, I don't see any reason for changing the rules. I haven't come across anything that, I mean, I don't like some of the things. I don't like the article, which we go on to the other article that we're showing there, which is, I think, what was it? Article 10, I think it was. Was it 10 or was it 15? 15, I think. Yeah, but Article 10. I mean, this is an odd one, but it has to be, and it works both sides. I mean, we've got two articles here. We got the 10 and the 15, I think it was, and the one is for the declaration of the port of destination. So that's the buyer has to give that, and the buyer has specific times in which to do that. And if he hasn't done it, the seller then has very specific times with which to declare in default. Otherwise, it's extended.
So you mean you need to send the shipping instructions on time, otherwise you open the door for the supplier to basically not perform.
Yeah. So if they haven't received them, then they've got to give notice, and they've got to give this sort of 2 working days notice, and then after two working days to put you in default, etc. And that is from the point of view of from the seller. Then you come on to the next one, which is the Article 15, and that's the same thing: advice of shipment or delivery. Now, this is one that we on the buy side have to look out for very carefully, because this is the one where we are waiting for a shipping advice. The market has gone screaming up, or the differential's gone out to the moon, and you're worried that your seller is not going to ship the goods, so you're watching out for it. And here you have specific time limits, and these have to be followed. So you've got to be careful, and as it says here, not later than 14 calendar days after the last day of the contractual shipping period or delivery period, the seller should advise the seller accordingly and give 3 clear working days notice that in the event that you don't receive the shipping advice, you will hold him in default with damages.
Yeah. So what you say basically is that the buyer needs to be very careful about sending the shipping instructions on time.
Yeah.
In case of a complicated situation, of course, and the seller should also be careful to send the shipping advice on time.
Shipping advice, but then the buyer has to be exceptionally careful in holding the seller in default if he hasn't shipped, and following that rule. That's why it's a complex rule, and it's one that has caused a lot of aggravation, because not later than 14 calendar days, give the guy 3 clear working days notice that if he doesn't give you a shipping advice, then you will hold him in default, and if you haven't received it within those 3 days, then you give him not later than 2 working days following the expiry of that notice. So you give him 3 days notice. The 3 days don't go by, he hasn't given you an advice, then within 2 days of that, so right on the 3rd day you can do it, but within 2 days. Now, if you miss out on those 2 days, then you've lost out. You haven't followed the timetable.
Yeah, but can you restart again? I mean, you lost it. You forgot. You went on holidays 2 weeks. You forgot. can you start again the arbitration saying, okay, I start again, I put you in default, and then, or it's too late?
Too late. Too late.
Too late. It's gone.
Because should the buyer not act strictly in accordance with the contract shall be deemed to be discharged without allowance. So the seller walks. He walks away.
Yeah, exactly. And to the people on the line, be careful, because if there's a problem and the people know the rules, then they're gonna try to make you miss the deadline, right, Angus? They're gonna try to gain some time, and they're gonna tell you, oh, I'm gonna come back to you tomorrow, no problem. I'm calling you on Monday, and then boom, they knew the rules. You didn't declare them in default, and your case is gone, right?
Yep, you got to be very careful, because a lot of these guys, particularly when the market's shot up and it's sort of all the differentials gone out wide, they know the rule, and they know that if they can spin it and keep you on the hook, not to put them in default, because they're such nice guys, then they can walk. So that's, you've got to, these are some of the things that in the contract that I don't particularly like, because they're so exacting. But then you see, I mean, when you look at the previous article where the seller has things to do, it is equally exacting. So what the European contract tries to do, it tries to be fair for both the seller and the buyer. It's got to balance. It can't just all be a buyer's contract. It is a contract for sellers and buyers. So it gives the same sort of 3 clear working days, 2 days, etc., etc. So it's a virtual replication of the other rules.
Yeah. And once you've been able to ask them to go into arbitration, force them to go into arbitration, then can you spell out the timeline for the arbitration procedure? I mean, you have 28 days in order to submit your case, and then what happens?
Well, once you've got your case, then you're looking at the BCA rules. You've got the contract rules, which gives you the time, 28 days, etc. And then of course you register your arbitration. So you go to the BCA and register the arbitration, or any other arbitral body that have got rules, and then the time follows from there.
So then you switch from the ECC rules, you switch to the BCA rules in order to start the arbitration procedure. Correct. Which will build your case, ask your claim on time, put the thing chronologically, as you stated.
Yep. And the BCA rules, it's all 21 days. You've got 21 days with which you make your registration. You then have 21 days to put your submissions in. Then the respondent has 21 days from receipt of those submissions. So if you want the case to go quickly, you can put your submissions in on the first day.
And then he's got 21 days from that date, right?
And he's got 21 days to put his submissions in from there. And then you have the right of response, 21 days, etc. So it's 21, 21, 21, but they can be speeded up if you are, you're the claimant, you can put them in straight away. Funnily enough, it's very rare that one gets submissions in much sooner than sort of 15 to 21 days. So even the claimant hasn't got his case. He's claimed arbitration, but he hasn't really thought about it too much, and then it goes on a back burner for a bit, and then he suddenly says, "Oh, I better do it."
Yeah. So when you have an issue, to everybody on the line, when you have an issue, you need to really follow up on it and not let it go. Keep the discussion open. Try to write down what happens. Keep your emails, right, Angus? Keep your emails, because you're going to put in the submission. Always put the dates, always put the deadlines. And then, of course, when you claim something, you should ask what you claim. Amount of money, the interest rate, if you paid somebody and you want to claim interest rates, or you want to claim other damages, other costs, legal costs, or internal costs, etc., right?
Yes, absolutely. I mean, as we said earlier, I've had arbitrations where basically the party has just thrown his filing cabinet at the arbitrators. It cost him a lot of money because the arbitrators got a hell of a job to do to try and sort it out, trying to find out what the hell it's all about. All the emails are in the wrong direction and all muddled up, etc. So keep it clear. I mean, you know, you just keep it clear, simple, and all your communication, every communication you've had with the party, and okay,
yeah.
Obviously you're making a case. You're going to try and win the case, so you may leave something out that you don't want arbitrators to see because it doesn't hold too well for your case. But remember, the other side is going to put in his submissions, and when the arbitrators see, look, he's left that out. What's he hiding? What's he up to, etc. So you know, it just we're arbitrators are just other traders, other people from the trade, other logistic people. So you know, we've done it ourselves. We know what tricks there are, etc. So keep it simple, truthful, and
straightforward, right? Exactly. Let's remember the people that when you ask an arbitration to go on, there's 3 arbitrators going in, 1 chair and 2 arbitrators. And for the appeal, it's a new set of 5 arbitrators, 1 chair and 4 arbitrations, right?
Correct. That's right. That's right. Yeah.
Which only see the award, so you need to resubmit your case, right?
Absolutely. The appeal is against the award. It's not against the submissions. It's not against anything else. It's purely against the award. So that the award is the only thing that the appeal tribunal will see. They don't see anything else.
Okay. Thank you, Angus. In order to wrap it up, one last thing. Can you maybe, I don't know, give us an experience you had, a special case you managed over the last years that was, I mean, that can illustrate, without saying names or even origins, that illustrates a bit what we said, and that maybe somebody who was totally right didn't win the case because of a lack of follow-up.
Difficult. Trying to think of it. We've had a few cases. Well, you know, I've seen a quality one which is thrown out because the time limits weren't met. But the main ones which get into problems is these Article 15 and Article 10 and 15 is where, you know, the notice hasn't been given correctly. The other one is, of course, where somebody is claiming, for example, I just had a recent case. It wasn't coffee, it was cocoa as it happened, but I'm not an arbitrator, but I was asked to help and guide somebody with their submissions in a cocoa arbitration. And it was an interesting one because the sellers had not shipped the goods to the buyer. And so the buyer asked early in the month, after the month of shipment, you know, have you shipped? They came back and said, no, we haven't shipped. They came back on the 6th of the month, after the month of shipment. They came back and said, no, we haven't shipped, but we're going to ship on the 15th of the month. So the buyer went back and said, well, I'm looking for an April bill of lading. This is not an April bill of lading now. And let me go to my buyer and see if he will accept. The next day he came back and said, sorry, we put you in default of contract. Now the thing marched on, and that was it. They put them in default of contract. The seller claimed arbitration, and he won his arbitration because cocoa rules are similar to our rules, the coffee rules, where there is a clause which you've got to give the 2 days notice and et cetera, et cetera, et cetera, as in this Article 15. And the first tier arbitrators decided that this didn't happen. He didn't do the right thing per the contract, despite the fact that he had already, the seller had basically brought an intention not to perform the contract by saying, or more than an intention, he said he wasn't performing. He didn't ship in April. He was going to ship later. He's already convinced that he was not, not performing. And so anyway, the matter appealed and was obviously the first tier was overturned. But it is a problem that, sort of, if you get a situation where somebody comes forward to you and says on the 6th of the month or the 5th of the month after the month of shipment, oh, I'm going to ship you in later in the month. They have said they're defaulting on the contract. They have said they breached the contract. What I would do there, my advice there would be, yes, you say claim the breach of contract, but when that 14 days comes up, follow the rule. Give them 2 days notice to give you a shipping advice, i.e. an April shipping advice. And if they don't do it after, 3 clear days, and then if they don't do it within 2 days, put them in default of contract and claim damages.
Yeah, so again, respect the timelines, because if you go into arbitration, you better know what you're doing.
Yeah, but that's a bit more than respecting the because he's already the guy's already defaulted. He's already said he's not going to do it. But just as a brace and belts on the thing, go and wait for those 14 days as well. Put them in breach of contract when they breach the contract. Do that, but then do this one as well. Follow up on that as well. Just in case.
Yeah,
I mean,
yeah.
This is not a coffee case. Thank goodness, because I hope our arbitrators act.
If you put them in breach of the contract, then they might not intend to ship at all on the 15 as they proposed. And sometimes it's better to get your goods than not at all, right?
Well, at the time when they said they were going to ship on the 15th, I mean, this particular buyer didn't want it for that. Mm-hmm. He wanted an April bill. He needed an April bill. He needed the goods for a certain buyer for a certain thing.
But then the buyer should claim something clear, like, oh, please find a replacement from elsewhere, from the spot, or.
Well, that's what they could have done. They could have gone and they could have found something afloat, etc., with an April bill and put that up. But they chose to say we haven't shipped April, but we're going to ship on the 15th of May. Well, hang on. If somebody says that, they're definitely in breach. And I guess it was a high price contract. So yeah, it must have been a high price contract, because otherwise the seller wouldn't have gone to arbitration. So it was a high price contract. The buyer didn't want it. He hadn't shipped on time, so he didn't want it.
Yeah. So the seller said, no, but you can't walk away because I'm late by 15 days.
Yeah, correct.
Yeah. Okay. Well, Angus, thank you very much. That was very insightful. We learned a lot from you. Thank you very much for your time.
Well, if anybody has any questions or anything, they know where to come. I won't advise them what they, about articles of the contract, which is something which I'll just tell them to read it very carefully and follow it up very carefully. They ask questions about it, I can answer the questions, but it's up to them to interpret the rules themselves. And it's something that I say to any of the associations or any of the secretariats of the associations: be careful. Don't actually advise people. Just point out the rule, and the rule is pretty clear.
Yeah, otherwise it's going to be your fault if it doesn't go right.
Yep, something goes wrong.
Yeah, that's true. Yeah, thanks for the advices. To everybody, this webinar has been recorded. We will publish it. I will send you the link, or we will put you in our SCTA Next Gen YouTube channel. So thank you very much for joining. I hope it was interesting. Do not hesitate to reach out if you have more questions on the subjects or if you have any suggestions for next webinars or topics to approach. And we wish you a great day. Thank you, Paul. Thank you, Angus.
Okay, well, thanks very much for organizing it all. You do a great job there.
Great. Thank you. Take care, everyone. All the best.
Bye.
Goodbye.